I'd like to welcome you all. My name is Brinkley Messick. I'm a professor of anthropology, and I'm a co-director of the Center for Palestine Studies. The center, as I suppose most of you know, was founded last year, and it's the first such center to be established at an academic institution in the Western Hemisphere. The mission of the center is to promote academic study of Palestine and Palestinians. This afternoon's session is the first in a new series sponsored by the Center on Palestine and law. We plan to continue in coming semesters with sessions on such topics as property, litigation, detention and imprisonment, and the legal status of refugees. The specific topic today is the state question, involving a set of legal issues that in some respects summarize the present predicament of the Palestinian people. The basic plan for the afternoon is for our three speakers, Susan Akram, Jamil Dakwar, and Nimr Sultani, to give short 20-minute, roughly, presentations. And then following that, Rashid Khalidi of Colombia will make a brief comment. And then following that, we'll open the floor for general discussion. We appreciate the hospitality provided by the Hyman Center, and I would like to thank in particular Eileen Gilloli. As always, our program manager, Ms. Mariam Zohani, has carefully and skillfully made all the necessary preparations. Our speakers, Susan Akram, is a clinical professor at Boston University School of Law, where she teaches immigration law, comparative refugee law, and international human rights law, and supervises students handling refugee and asylum cases in the university's Asylum and Human Rights program. She's a graduate of the University of Michigan in Ann Arbor and of Georgetown University Law Center, where she got a JD, and the Institut International des Droits de l'Homme, Strasbourg, where she got a diploma in international human rights. She's a past Fulbright Senior Scholar in Palestine, which involved her teaching at Al-Quds University, the Palestine School of Law in East Jerusalem. Her recent publications include a co-edited book, International Law and the Israel-Palestinian Conflict, a rights-based approach to Middle East peace, 2010. Second speaker, they've not arranged themselves in order here, but that's okay. Jamil Dakwar is Director of American Civil Liberties Union Human Rights Program. Prior to joining the ACLU in 2004, he worked at Human Rights Watch, and before coming to the United States, he was a senior attorney with Adalah, the Legal Center for Arab Minority Rights in Israel. He's a graduate of Tel Aviv University and NYU School of Law. He regularly writes and speaks about legal and human rights issues in Israel and the occupied territories, and he served for 3 years as an editorial committee member for the Journal of Palestine Studies. Nimr Sultani, our third speaker, is a doctoral candidate at Harvard Law School. He has law degrees from the College of Management, Tel Aviv University, and the University of Virginia. His doctoral work focuses on contemporary progressive constitutional and political theory. He's worked for the Association of Civil Rights in Israel and Mada al-Carmel at the Arab Center for Applied Social Research. His publications include Citizens Without Citizenship, Israel and the Palestinian Minority, in 2003, and an article in the Harvard International Law Journal Online, The Legacy of Justice Aharon Barak, a critical review. This is the former Chief Justice of the Israeli Supreme Court. And Redrawing the Boundaries of Citizenship, Israel's New Hegemony, in the Journal of Palestine Studies. Rashid Khalidi is the Edward Said Professor of Arab Studies at Columbia University. He is a professor of history and a former co-director of the Center for Palestine Studies. He received his BA from Yale University and a PhD in history from Oxford University. Khalidi is the editor of the Journal of Palestine Studies, and he was a past president of the Middle East Studies Association. He's been an advisor to Palestinian delegation to the Madrid and Washington Arab-Israeli peace negotiations in 1991 and 1993. He's the author, as you may probably all know, of many books, including Sowing Crisis, American Dominance and the Cold War in the Middle East, The Iron Cage, the story of the Palestinian struggle for statehood, and Palestinian identity, the construction of modern national consciousness. So our first speaker is Susan Akram, who will speak about her work on Namibia, Southwest Africa, Palestinian UN strategies.
Thank you. Thank you very, very much for inviting me. It's a pleasure to be here. I think I was last here when there was a UNRWA at 60 conference with the really engaging presentation by the three prior UNRWA Commissioner Generals. I'm going to kind of lay the background for the discussion that I hope will be generated by all four of us by giving a little bit of a historical comparison to this bid for statehood by the Palestinian leadership and do it through a comparison with perhaps the most close parallel in the international realm, which is Namibia. As you all know, and you're all probably watching very closely, the PA submitted its application for statehood for Palestine at the General Assembly and for membership in the UN at the Security Council at the opening of the General Assembly in September. And these applications, they're often lumped together, but we are going to separate them in our discussion because they need to be separated to understand them, have been lumped together and called Palestine's statehood bid. It's generated a great deal of discussion about what recognition of Palestine as a state would mean for Palestine and the Palestinians, and whether anything would really change in the absence of real territorial independence. So I want to address this question by way of this comparison between Palestine and Southwest Africa, Namibia, and what legal strategies have been followed in both cases at the United Nations. And in this work, I really want to thank Stephanie Khoury, who contributed a great chapter in our book. I highly recommend looking at that. She actually compared Southwest Africa, Palestine, and Western Sahara as far as strategies in the United Nations, but also the work of John Quigley in his just published book, The Statehood of Palestine. So I'm going to draw on some of their work in my discussion. So why should we compare Palestine and Southwest Africa? Namibia and Palestine had very parallel histories in terms of the way they began their campaigns towards self-determination and independence, and in the way their status was addressed at the League of Nations first, and then later at the United Nations. So comparing these two histories is really helpful to understand two particular issues. First of all, the different ways in which law provides a framework for attaining statehood. And second, whether independence is a necessary precondition to statehood. And what I'd like to illustrate through this presentation is the critical role that law has played and legal strategies have played in the United Nations and elsewhere, for example, in the Namibian bid to statehood in the absence of independence, and how the absence of a clear and sustained legal strategy on the part of the Palestinians has affected their bid for statehood in the absence of independence. So our question is, can what Namibia achieved be achieved by Palestine through this bid at the United Nations? So to give just a very brief historical background, at the end of World War I, the great powers incorporated various kinds of supervisory arrangements with former colonial or Ottoman territories into the League of Nations Covenant and the Treaty of Lausanne, which ended the Ottoman Empire. This plan created three classes of territories, and they were claimed to be at different stages of development and established that they would be under the mandate or supervision of one or other of the great powers. The League of Nations Covenant placed Palestine among the Class A mandates, or those that were supposedly closest to independence, along with Iraq, Lebanon, Syria, and Transjordan. And Britain, as you all know, was given the mandatory power over Palestine. At the same time, Southwest Africa, Namibia, was among the Class C mandate territories, and it was considered the farthest from independence under the League of Nations Covenant Article 22. In fact, for Namibia, independence was not contemplated at all by the League, as it was not for all Class C territories. Namibia was placed under South Africa's mandate. On April 18, 1946, the League dissolved, leaving all the mandate countries continuing under the terms of Article 22 as trusteeships under the new United Nations, except for Syria, Lebanon, and Transjordan, which by then had obtained independence. Now, South Africa almost immediately had sought to fully incorporate Namibia as South African territory, but the UN refused, and the General Assembly voted to put Namibia under trusteeship under the UN Charter. South Africa refused that, and that began a lengthy battle at the United Nations. Almost immediately, the General Assembly filed the first of 3 requests for advisory opinions from the International Court of Justice on various questions relating to the status of Namibia. And the Security Council later filed another advisory opinion with the International Court of Justice. And finally, in this panoply of litigation advisory opinions, Liberia and Ethiopia filed a contentious case challenging South Africa's apartheid policies and its failure to comply with the UN requirements towards Southwest Africa. In October of 1962, the United Nations terminated the South African mandate, placed Namibia under direct UN responsibility, and set up an ad hoc committee for Southwest Africa to recommend, quote, means of administering Southwest Africa to enable the people of the territory to exercise self-determination and achieve independence. The General Assembly also established the Namibian Council to administer territory until independence. Although South Africa did not recognize Namibian independence and did not withdraw from the territory until 1988, the world community, following the actions taken at the United Nations and at the ICJ, had created a defined legal framework for Namibia's status, declared its independence, imposed sanctions on South Africa, and created the mechanisms to implement independence over a period of 20 years before independence was actually achieved. And this was so even though the Security Council never voted to take Chapter 7 enforcement action to force South African withdrawal from Southwest Africa. So much of these developments occurred through what I call a robust legal strategy involving submissions to the International Court of Justice and work within the UN General Assembly from the start. In contrast, Palestine, as I mentioned, a Class A mandate, and the only state of the Class A territories not to achieve independence by the time the League terminated in 1946. It's true that Britain had incorporated inconsistent provisions into its mandate terms, including, on the one hand, the covenant commitment to bring Palestine to independence, and on the other, the Balfour commitment of securing a national home for the Jewish people. At the same time, the actual foundation for recognition and the legal framework for Palestinian independence was not developed jointly by the General Assembly and the Security Council, and there has been minimal effort to obtain rulings from the International Court of Justice to support Palestinian self-determination claims. Continuing Palestine as a UN trusteeship territory in 1946 was objected to by the Arab states. Similar to South Africa over Namibia, the UN accepted Britain's commitment to obligations under the mandate rather than putting Palestine under direct UN trusteeship. The General Assembly's ad hoc committee to study proposals on the future government of Palestine rejected the Arab and other states' early proposals to obtain an International Court of Justice advisory opinion, and instead, as you all know, recommended partition. The General Assembly then passed Resolution 181 in November 1947, recommending partition of Palestine into 2 states, which the Jewish Agency accepted, the Arab High Committee rejected. And Israel declared its state in May 1948, then gaining control of 77% of historic Palestine, well beyond the borders of 181. So a year later, the General Assembly passed a really critical resolution, General Assembly Resolution 194. And it's a critical resolution because it is the key resolution incorporating the individual rights of refugee return, restitution, compensation, and conditionally accepted Israel into the United Nations pending compliance with 194. Israel did not comply after admission, and surprisingly, after 181 passed, the Security Council first asked members to study partition, but then backed away from it and requested the General Assembly to reconsider, including a possible trusteeship for Palestine. However, soon after 181 passed, the General Assembly and the Security Council began to act in very different and inconsistent ways toward Palestine, with the General Assembly developing a significant body of resolutions affirming both the individual rights of, for example, refugee return, property restitution, and compensation, and the collective right of self-determination, statehood, and independence. And the General Assembly has, since that time, insisted on this framework as the one for peace negotiations. In contrast, the Security Council's framework has almost exclusively focused on two resolutions, 242 and 338, as the basis for a negotiated solution. Now, these two resolutions create what is commonly known as the Land for Peace formula, that suggests that the only legal framework necessary to resolve the conflict is some exchange of territory for a permanent peace. Most critical, the Security Council has failed to affirm Palestinian inalienable rights, self-determination, statehood, the rights of refugee return, and Israeli withdrawal from 67 territories, which, as I mentioned, have been the focus of the General Assembly's framework for resolution of the conflict. The Security Council has also blocked UN-sponsored conferences by vetoes or by refusing to consider General Assembly recommendations. The Security Council's entire approach has been framed by the Land for Peace political formula as a basis for negotiations, with almost no reference to legal rights. Moreover, in marked contrast to Namibia, there has been exactly one submission to the International Court of Justice in over 60 years, the advisory opinion on the wall of 2004. It's my contention that it was the lawmaking that took place through the International Court of Justice and in other legal venues that contributed to a significant degree to Namibia's achievement of statehood in the absence of independence. In contrast, it's the absence of such lawmaking that may prevent Palestine from achieving statehood in the absence of independence, even if it obtains formal recognition. Let me make a few more comparisons between these two cases that illustrate the legal strategies in both cases before moving on to implications for statehood, and I may actually just leave the implications for question and answer. Namibia's independence was acted upon as a matter of legal right almost immediately after the mandate period ended, even though, as I said, it had Class C status while Palestine had Class A status. The PLO, in response to the decolonization efforts within the UN by the African states, made a very deliberate change in strategy in the United Nations in the mid-1960s. By 1969, the resolutions that were proposed and passed at the UN on Palestinian issues had changed their language from that of individual rights to calling for rights of the Palestinian people or collective rights. This may have seemed like an appropriate strategy at the time, but by failing to merge individual rights with the collective, the PLO has been forced now at the negotiating table to exchange one set of rights for another, and we can actually track that through the various negotiations from Madrid to Taba. The Palestinian strategy has focused on ending occupation and calling out violations of international humanitarian law, rather than a combined strategy demanding fulfillment of both individual rights and the collective rights of self-determination and independence. Meanwhile, the Security Council's position has been consistent in reaffirming only 242 and 338 as the basis for a negotiated peace. In turn, the negotiation framework from Oslo onwards, with limited exceptions, has referenced only these two resolutions, 242 and 338, and none of the General Assembly individual rights resolutions. This approach, to my mind, has been a deliberate omission of law in favor of a purely political solution. In the Palestinian case, we see the General Assembly and Security Council in deep conflict. Unlike in Namibia, the legal framework articulated by the General Assembly in the Palestinian case has been virtually ignored by the Security Council. In the Namibia case, the General Assembly and Security Council came up with an agreement on the underlying legal framework. The Security Council came to the agreement reluctantly and late because of the actions of several of the permanent members, but in the end, the Security Council had no choice because the International Court of Justice, in its 4 advisory opinions, one in answer to the Security Council itself, was consistent in its statements of what the law required. Namibia's relationship to the Security Council was similar to Palestine in the sense that the Security Council took no enforcement action to implement, for example, the sanctions that had been demanded by the General Assembly, or to call for intervention because of French, US, and UK vetoes. Yet, because of the ICJ endorsement of sanctions against South Africa and the insistence by the ICJ of the obligations of all states to bring about Namibian independence, the sanctions regime was legalized to support individual states' actions towards South Africa. In other words, like for Palestine, direct Security Council enforcement of resolutions based on General Assembly rights framework has been blocked by the veto of a permanent member. But in Namibia's case, the legal strategies were not defeated by failure of the Security Council. Before and after the request of the International Court of Justice for an advisory opinion on the wall that was issued in 2004, there has been no effort by the Palestinian delegation at the UN to work on advisory opinions as a distinct strategy, despite the solid support that the PLO has within the General Assembly, especially with the group of non-aligned states. So in contrast to the 4 advisory opinions in the contentious case litigated over 2 decades for Namibia, Palestine has obtained 1 advisory opinion with very little follow-up to use it as any kind of an effective tool. The PLO-PA has also failed to work within the EU, regional and other mechanisms, or file lawsuits in domestic courts as the Namibian Council did for Namibia to protect its resources and interests. The Palestinian leadership has also failed to incorporate careful legal strategies in the negotiations frameworks, as I mentioned, insisting, for example, on the inclusion of 194, refusing to allow discussion with the separation of the West Bank and Gaza as a single territorial entity, and rejecting the narrow focus on the 242-338 framework that has been insisted upon by Israel. The Palestinians have taken an almost entirely political rather than a law-based approach to the UN. In fact, it can safely be said that they have not been committed to a legal strategy in general in pursuing their goals. Evidence of this is the lack of effort to expand and build on the roles of the Palestine Committee and the Palestinian Unit, working against them and against civil society activists engaged with those entities rather than with them. There was, in fact, no legal department advising the PLO-PA until the Adam Smith Institute established the Legal Affairs Department after Oslo. Even so, the PA has not made much use of the Legal Affairs Unit's work at the international level. One can safely say that the Palestinian leadership has failed to see the importance of legal strategies, along with political negotiation, media, and civil society collaborations. Namibia, as well as South Africa's ANC, it's important to note, did not give up the armed struggle until equality and independence were achieved. So let me very quickly now separate the 2 questions that are up at the UN, the statehood from membership. As I mentioned, the Palestinian leadership has raised 2 separate issues at the United Nations. One is recognition of Palestine as a state, and the second is a request for membership in the United Nations. And they need to be thought of differently, as they are independent of each other. Beginning with the question of statehood, there are 2 views of when a territory or people are a state as a matter of international law, and states have not acted consistently on this issue. One position is that statehood is a function of the declaration or simple recognition by other states. The other is that it is a function of recognition plus other factors, which may or may not include independence. So far, over 100 countries have recognized Palestine as a state, and up to 150 may do so. Is this enough for Palestine to be a state? The common arguments against Palestinian statehood are that, one, it was not historically a state; two, it does not meet modern-day statehood criteria; and three, Palestine has not been recognized as a state by the international community. John Quigley, in his book, The Statehood of Palestine, argues that there are four errors in these claims. And I will just run through them very quickly. First, historical facts show that Palestine was a state from the Mandate period onwards. Second, Palestine is being asked to meet criteria for statehood that are more stringent than have been required for other states. Third, the criteria do not take into account the effects of prolonged occupation. And fourth, that Palestine has already been recognized as a state both explicitly and implicitly in the international arena for several decades. The most commonly accepted standard for the elements of statehood is the Montevideo Convention of 1933. This convention requires a permanent population, a defined territory, government, and the capacity to enter into relations with other states. Since Montevideo, it's also claimed that an additional element is required for statehood, and that is independence. Quigley advances the case for Palestinian statehood with a sharp critique of the criteria set out in Montevideo. He argues that the Montevideo Convention was intended to clarify that independence was not a prerequisite to statehood, and that state practice has not changed to require this. He then makes the case that Palestine presently satisfies all the conditions in this convention: a permanent population, a defined territory, government, and the capacity to enter into relations with other states, and that Palestine does not have to be territorially independent to be a state in the international arena. There are, of course, many examples of states that have been recognized without having territorial independence, including our primary illustration, Namibia. Other examples are prior Soviet satellite states, Monaco, Belarusia, the Ukraine, and I have a list. Quigley lists them in his book. The quartet has stated that a Palestinian state could be established prior to the conclusion of final status negotiations with Israel, and in fact the quartet's framework holds out that based on negotiated agreements, the PA can assert its claim to statehood with provisional borders and attributes of sovereignty even before full Israeli withdrawal. That was also the basis of the Oslo Accords. Aside from the over 100 countries which have already established diplomatic relations with Palestine, it has a functioning government in the West Bank and Gaza, with a president, prime minister, cabinet, legislative council, ministers voted by open elections held in 1996. Moreover, there's a civil service comprising thousands of employees. There's an established court system with first impression and appellate courts, as well as a high court. Palestine has a central bank and even its own internet domain name. Perhaps since the Hamas-Fatah Accord, there will soon be a unified government. Don't hold your breath. But even divided government does not defeat statehood. For example, Korea, Vietnam, and Yemen have been divided states, yet that has not prevented their recognition of statehood. Palestine, then, if it gains formal recognition of a majority of states, should fit the requirements for recognition plus all the other elements of statehood besides independence. Let me briefly touch on UN membership, and then I will leave the consequences for later discussion. Article 4.2 of the UN Charter says that a state may be admitted to membership by a decision of the General Assembly upon receiving a recommendation from the Security Council. The International Court of Justice in the 1950 admissions case made it very clear that the UN Charter places responsibility for admission of state membership in the United Nations squarely on the Security Council, and that the General Assembly cannot act on state admission without Security Council recommendation. So if the US vetoes Palestine's application for membership, then Palestine will not become a United Nations member. Instead, its position would be similar to that of Kosovo, whose admission is blocked by Russia, and Taiwan, whose membership is being blocked by China. U.S. opposition to Palestine's membership of the UN, however, would not necessarily affect Palestinian statehood, Palestine's statehood. If 150 states do recognize Palestine at the UN, statehood and membership in international organizations are entirely separate matters, as the examples I've mentioned show. So assuming that 150 states, including those from the EU, recognize Palestine as a state, does the Namibia case tell us that Palestine can effectively become a full-fledged state even without independence? And if so, what are the consequences? Very quickly, it depends on what those 150 states do with their recognition. Full recognition, representative status, where will their embassies be? Will they recognize Palestinian passports? Will they allow full freedom of movement, issue visas, and so on? What will be the recognized population from the point of view of the world community of states? Palestinians in the occupied territories, within Israel, in the diaspora, Palestinian refugees? And if they become Palestinian citizens, do they cease being refugees? And then what happens to all of the rights that they claim as refugees? Third, if we assume that Palestine will be treated equally on the diplomatic front, there would be full relations with states that recognize her, but not with those who do not, say Israel and the US, hypothetically. Palestine is already a member of international organizations, but it can join the full panoply of international organizations. However, if in attempting to increase trade and obtain the benefits of these organizations, the relationships remain in effective control, in Israel it's questionable to what extent the benefits will actually be realized. What does it mean for recognition in other international organizations if the US and Israel oppose? We've already seen that begun to play out in the UNESCO after the UNESCO vote, admitting Palestine and the US and Israel's responses. We'll have to see on a case-by-case basis, but as we've seen at UNESCO, at each venue where Palestine takes her place as a state, say at the Human Rights Council, Israel and the US will object, delay, and likely take punitive action in response to Palestinian admission. Again, on question of consequences, what can Palestine do to enforce the territorial integrity of the West Bank and Gaza in the absence of withdrawal of Israel? What can it do to enforce withdrawal of settlements or even implement a uniform legal system in the West Bank and Gaza in the absence of withdrawal? It's also true that Palestine will have sovereign immunity, but in the fora in which this is a particular problem, US courts, if the US does not recognize Palestine, it will make no difference for the lawsuits in which Palestinian defendants have been sued as terrorists. I have many more examples, but I will stop there and simply say these examples of the consequences of statehood without independence illustrate that in the absence of a clear body of soft and hard law to support the actions of those countries supporting Palestinian statehood, continued Israeli and US opposition to Palestine's recognition of a state may make this an exercise in futility in some of the ways that matter the most to the Palestinian people: the fulfillment of their individual rights of return, to restitution of their properties, as well as their collective rights to full recognition as a people connected to their own land with all the freedoms such recognition ordinarily brings. What the Namibian case shows is that for over 20 years before actual independence, Namibians and their supporters had a strong legal strategy, combined with the political and the armed struggle, that resolved many of the key issues, allowing the non-rejectionist states to make the statehood bid meaningful by the time actual independence came about. The outcome of this bid for Palestine, in contrast, is highly uncertain. Thank you.
Jamil Dakhar will speak about the implications of potential upgrade of the PLO's observer status for the question of human rights accountability. Jamil.
Thank you first for the invitation, for organizing this important discussion. I want to first say that I'm here to speak in my personal capacity and not representing the ACLU, an organization that does not take position and get involved in those kinds of foreign policy matters. So anything that I say, this is my views and my personal views only. I also want to echo some of the things that were said by Suzanne about the conflation between UN membership as well as recognition as independent state under international law. I think that conflation really goes into the heart of what I argue is the heart of the lack of clear legal strategy by the Palestinian leadership. But I also want to note that it may be too early to judge and to know whether really it was a failed exercise or it was a successful strategy or not. It might take some years to get maybe another Al Jazeera Guardian leak of papers, who knows, to get us what exactly happened and what are the thinking behind this move. But it was clear from the history or the track record of the Palestinian Authority in particular, which is really an Oslo creation entity. It's not something that was created before, and the marginalization of the PLO and its legal entity was brought to the surface under this discussion and the debate around Palestinian statehood. And I also want to note here that there is clearly a crisis in the leadership, not only a political crisis, but also a legal crisis. I don't know how many of you have heard of the Palestinian Attorney General or the Palestinian Minister of Justice. Whether we do have a clear visionary and legal authority in the Palestinian leadership to be able to back the Palestinian leadership with whatever political decision that they make. And I think that is part of where we are right now. So let me start by saying a little bit of the background, the political backdrop of how we got here. First is the failed political talks, the so-called peace process, negotiations between the Palestinian Authority and the PLO, if you wish, and Israel, sponsored by and large by the United States government. And the failed talks, despite and notwithstanding Palestinian willingness to recognize what I would use the quote that was Saib Arakat's words, the biggest Yerushalayim in Jewish history, end quote. This is something that Saib Arakat had said during the endless negotiations between the Palestinian Authority and the Olmert government, in which the Al Jazeera and the Guardian papers discovered or surfaced the fact that the Palestinian leadership was in a position to give Israel most of its demands over sovereignty, particularly in the area of Jerusalem. And you can go and see them for yourself. So you have that first major crisis or major event happening. Failed political negotiations after almost 20 years of negotiating since the Madrid talks. And then you have the Palestine papers, which I briefly mentioned, and we won't have time to go into, but I think they also are important to mention because for the first time we had documents that the smoking gun, if you wish, of what has happened behind the scenes and what was really said or what was not said, and what are the reactions of different parties. Very, very concise notes that were taken by people who were eager to document the record, which I think did a very good job in doing so. But that's important because the Al Jazeera Guardian or the Palestine papers were immediately overshadowed by the Arab Spring and the eruption of the revolutions both in Tunisia and Egypt. I think the papers the Al Jazeera papers were disclosed sometime in December of 2010, and you have January right after the beginning of the year, the Tunisian and Egyptian revolutions, and then all of the discussions about the Palestinian leadership and the role of Saib Arakat and others in mismanaging the strategy, not only the political strategy, but also mismanaging one of the most important projects that was supporting the Palestinian Authority and leadership since in the last decade, which is the negotiating team unit or support negotiation support unit, which I think was a worthwhile project, except it was directed by the wrong hands, or put in the hands of the wrong person to direct and to instruct. With all of this, you have United States government, particularly on the issue of accountability, siding clearly with Israel, just like other positions, undermining attempts to hold Israeli officials accountable. And the Goldstone report and the way the role that the U.S. government played is also important to note here, and something to be learned from, where you have a highest level of the U.S. government, particularly the legal advisor and the Assistant Secretary of Human Rights, take their first joint trip overseas to Geneva in September of 2009 in order to essentially bury the Goldstone report in the Human Rights Council, and not to let it go out of the Human Rights Council, not to go and to be a possibility of avenue of accountability, first of its kind since maybe the first reports of accountability, that the commissions that were reported back in the 50s by the United Nations. And here also, it'd be interesting to look at the WikiLeaks cables that were released in the last year and to look specifically at the US government position. I won't have time to go into that. But the more important thing is where we are in terms of the three options. And my interest is looking at what are the implications of recognizing a Palestinian state as an independent state to the issue of accountability for human rights. Both seeking accountability before international institutions like the International Criminal Court, as well as other international legal bodies. And I think here, this is where I think the strategy went wrong. If the Palestinian leadership and the PA, the Palestinian Authority, was truly interested in holding Israel accountable for what happened, for example, in the 2008-2009 Gaza invasion or attacks in Gaza, it would have been more taking the position that it is not really about membership in the United Nations that will determine the likelihood of accountability mechanisms. It was really more about recognizing Palestine as an independent state, doing the more bilateral recognitions, receiving those state-by-state recognition that will foster and imperfect their attempts to hold the Israeli government accountable. And yet, of course, for those of us who've been following the PA, because of its poor track record in upholding Palestinian human rights, both during the early years of the Oslo Accord and what the PA has done in Gaza and other parts of the West Bank, as well as their complicity in undermining accountability for human rights and the way that they dealt with the Goldstone report when they agreed to take it off of the schedule or the discussion from the Human Rights Council. For those of us who've been looking at this track record, we knew that raising the idea that membership in the UN or recognizing Palestine as a state is really going to hold Israeli government accountable. And we knew that that was a false premise. And the underlying goal was more about a political recognition of the Palestinian Authority and its own leadership without really careful consideration of the implications on accountability for human rights. And I will clarify what I mean by that. The PLO has already received the most advanced status in the United Nations system for non-state actor. This, by the way, is not something that the UN Charter mandates. This is something that is worked out within the General Assembly rules. The UN Charter only mandates the issue of membership in the United Nations, and that in of itself does not have any direct implications on whether the country can hold other countries accountable for example, commission of war crimes, crimes against humanity, and genocide. Because to be a member of the International Criminal Court, you don't have to be a member of the United Nations. You have to be a member, you have to be a recognized state, independent state. I want to mention a simple fact which is often forgotten. Switzerland, for example, for years was not a member of the United Nations, and yet it was an independent state with full relations and agreements with the international community. There was also situations the other way around, where, for example, countries which were not recognized as states were full members of the United Nations. I think India was in that position in the early years. For the Palestinian Authority to argue that we're going to take the case against Israel to the ICC and our membership within the United Nations, or our taking the bid to the United Nations and making it the focus, or at least one of the main goals for this campaign, is obviously misleading. The important example for such a move is to look at how the Palestinian Authority dealt with the issue of statehood from a point of, we are now in a very difficult political climate. We have a forced unity agreement with Hamas, which was influenced greatly by the Arab Spring. We have a movement in the Arab world calling for justice and accountability. And where would we be standing? On what side would we be standing? The Palestinian leadership made the calculations that we would want to turn our UN bid into the sort of democratic revolution of Palestinians, forgetting the record, everything that was revealed about the Palestinian Authority, and that this does not necessarily mean getting UN membership does not necessarily mean that it will get full accountability. If you examine the Israeli positions and reactions to the Palestinian statehood bid, you would see that the most concerning issue was the issue of full recognition as a state. They were more concerned about what the PA and the Palestinian Authority and the leadership was doing in different capital cities than what really was doing in the United Nations. Why? Because that is really what matters. In fact, Netanyahu in September said that he would agree to upgrading the status of the PA within the United Nations, but up to the level of non-state. Non-full state, non-membership. I think he was then talking about recognizing it as a Palestine independent state. And we know that there were attempts which were largely led by, at the time, Catherine Ashton, the European Union Foreign Policy Chief, who went on her own. I think it wasn't really something that the EU in general embraced. And under that proposal, the PA would be upgraded to a new legal status, less than that of a state. And this status, according to this proposal, would not allow the PA to have standing before the International Criminal Court, essentially blocking the Palestinian Authority and that whatever state is going to be called or status that they will have from continuing to pursue accountability before the ICC. I must backtrack a little bit and mention that the Palestinian Authority under Mahmoud Abbas, even if they were encouraging quietly the Israelis to go after Hamas in 2008, 2009, and again you have some good documentation around that, they were concerned that public opinion will go against them. So what they did, they rushed to The Hague and filed signed papers accepting the jurisdiction of the International Criminal Court over the so-called Palestinian Authority of Palestine, and asked the court, the prosecutor in this case, the Campo, to examine Israeli violations of the ICC, the Rome Statute, as far back as 2002. This request is still pending. I should have mentioned this in the beginning. The prosecutor is still examining this request. First, whether the Palestinian Authority has standing or can accept as a non-member state, non-state actor to come and ask for such an investigation, and whether there are merit to the investigation or opening investigation under the ICC statute. Of course, here, again, the conflation between law and politics, again, as if the ICC, the International Criminal Court, even if the state of Palestine was truly independent, this will be something easily to achieve. I would argue that for people who are, again, watching the ICC and the track record of the International Criminal Court, which by some is called the African Court, because it's the only cases that it has initiated since it started in 2002, were African cases, most recently, which I think were maybe the most important ones, against Muammar Gaddafi, his son, and the Minister of Intelligence. But nevertheless, people really don't underestimate the politics of initiating such a procedure, the way that this court interacts with the rest of the world, particularly subject to diplomatic considerations, some people would say pressures, financial support, and many others. And I think there are others who are experts in ICC will tell you more about that. But that is a fact, meaning even the Palestinian Authority was interested in pursuing a case before the ICC to recognize the limitations of this and not to promise too much to the Palestinian people where they would not be able to deliver. And I would want to end with first of all saying that I think, again, if the political strategy would be backed by the right and sound legal strategy, which is, if you are truly interested in accountability and for at least having a better shot at, for the first time, holding the Israelis accountable for war crimes and crimes against humanity, you would be focusing again on the issue of independent state rather than distraction of the United Nations bid, which I think created more animosity and some maybe would argue backlash as the UNESCO one, which would not be the same backlash if you had governments and capitals stating clearly and loudly in response to the Palestinian leadership request, we are going to recognize. And they would go one by one. Finland, I think, was the last one, which the first European, Western European country to say that they would do that. And I think the Palestinian leadership should be commended on this track of trying to get and secure recognition in the Palestinian and not too much distraction within the UN bureaucracy, where it's, again, if you get the Palestinian for Human Rights, the Center for Palestinian Human Rights updates, you would have got an email today that says the Palestinian Authority and the PLO leadership yet again failed to take up the next step with regard to the Goldstone report within the UN body. The Sixth Committee of the United Nations General Assembly was supposed to take an action, and it would take an action only if it's initiated by, in this case, the PLO, because the original resolution of the Goldstone report invested this in the PLO, and yet they failed to take action. So not only we have Justice Goldstone coming against himself and his own commission and say, well, you know, I have to re-examine, I've had bad dreams, and I think now it's not the right thing what I said. And by the way, Justice Goldstone failed to recruit not a single member of the commission, of his commission. If there were really merits to what he was saying, the one thing you expect that he would go back to his commission and try to get at least one or two on his side before he goes and publicly make his opinion in the Washington Post and New York Times. But the last thing I want to finish with is the following. And that is maybe an advice or maybe a lesson learned from all this exercise, which is what is lacking in the last 20 years has been a central role, or the lack of central role, or no role at all maybe, for international rule of law or international accountability for human rights framework, international humanitarian law, in the Oslo Accords, post-Oslo Accords, and all the negotiations since then. If you look at other situations of international conflict, and in particular I want to cite the former Yugoslavia, you would see that international community responded, and there were more commitment to the creation of accountability mechanisms before reaching a political agreement. And in fact, the ICTY, the International Criminal Tribunal for the former Yugoslavia, was created before the Dayton Agreement, which was concluded in Ohio in 1995. And I just want to read a quote from, I think it's a historic quote, because of the reason that you know who is behind this quote. In 1995, days after the Dayton Agreement was concluded, the chief prosecutor of the International Criminal Tribunal for Yugoslavia, Justice Goldstone, and the late Judge Antonio Cassasi, Italian judge who passed away unfortunately in the last several months, had this to say about the Dayton Agreement, which was signed in 1995. They've been working on the international accountability since 1993 by a Security Council resolution. And they said the following: justice is an indispensable ingredient of the process of national reconciliation. It is essential to the restoration of peaceful and normal relations between people who have had to live under a reign of terror. It breaks the cycle of violence, hatred, and extrajudicial retribution. Thus, peace and justice go hand in hand. This agreement, the Dayton Agreement, promises that those who have committed crimes which threaten international peace and security, genocide, crimes against humanity, and war crimes will be brought to justice. I think this is one of the kind of lessons learned. If we really truly interested in accountability, at the very least, we have to be guided. All the political negotiation settlements has to be conditioned on a meeting international legality, not only in terms of the agreements and issues of sovereignty, but also on the question of accountability for human rights that will ensure that people will be held accountable and will send the right message to both the Palestinian leadership and the Israeli government in this case. Thank you.
Now we have Nimr Sultani, who will speak about the limits of legal strategies.
Thank you for the invitation. So I'm what you might call a self-hating jurist. So instead of looking at the ways in which the law can advance the cause of the plight of the oppressed, I'm interested in the ways in which the law obscures power relations, blinds us from seeing reality, and mystifies the situation at hand. And because I think that the legal field is always already political, and therefore I don't believe in a distinction between law and politics, I will start with the political, I will move to the legal, and the legal will bring me back to the political. Essentially, I'll be arguing against two things: against the fetishism of statehood and the fetishism of law. And in the end, I will go back, with your permission, to Namibia, because I have a different take, so I will throw some disagreement into the room. Forgive me for that. But I want to start from Karl Marx in the 14th Brumaire of Louis Napoleon. There he starts the first paragraph with the following modification of Hegel. He says, historical events and personalities occur twice, once as a tragedy and the second time as a farce. We have been there, we have seen that. Let me remind you, the 4th of May 1999 was supposed to be the last, the end of the interim phase of the Oslo agreements, the 5-year transitional period. At the time, Arafat was leading what was called the offensive, the diplomatic offensive, the same way Abu Mazen called his diplomatic offensive, and in which he was moving from one capital to another, and he was threatening to declare statehood on the 4th of May 1999. The prime minister in Israel was, like today, Benjamin Netanyahu, and he had the same perspective or the same policy with respect to the Oslo Accord. Arafat was threatening to declare statehood and independence, and Netanyahu said this will be a violation of a unilateral move in violation of the Oslo Accords, and therefore will justify unilateral moves by Israel. In March 1999, President Clinton met President Arafat and urged him not to declare because this will damage the political climate and will affect the upcoming Israeli elections. The end of the story we all know. Arafat retreated from his intent to declare independence, and against the backdrop of a European Union declaration reaffirming the right to self-determination of the Palestinians and an American promise of greater involvement in the negotiations. At the time, Azmi Bishara wrote in the Journal of Palestine Studies the following, and I want to quote because I think this is correct to today's scenario, although this has been written in 1999. Quote, if the PA goes ahead and declares a Palestinian state, the principal issue will immediately shift to securing recognition for that state. Israel will act in such a way that the Palestinians will have to deplete all their energies securing the recognition and indeed the survival of the state. The declaration of the state would accelerate the conclusion of a permanent settlement on Israeli terms. Declaring a Palestinian state within the present borders of the PA would not alter the existing balance of forces, but would take place within it. The Palestinians will become the prisoners of their very achievement. Why would we expect the existing structures to change by the simple fact of the declaration? Unquote. The end of Arafat, as we all know, was tragic. But the reincarnation of the 1999 episode in 2011, I think, is a farce. At bottom, is nothing more than a farce. And there are many reasons for that. It's not only that seemingly the Palestinian Authority did not anticipate the procedural hurdles that this thing can be dragged in the UN halls for a long time. One member of the Palestinian delegation at the time told the press that this history in the making will not take longer than a few weeks. We are now 10 weeks after that, and we don't see the end any near. But there are more profound political and legal reasons to which now I will move. Politically, there was a need for a crisis. The PA should have produced a crisis in order to demonstrate that the Oslo Accords have led to an impasse and that there are worsening conditions on the ground, and therefore there is a need for international intervention. So the PA rightly produced a crisis. But I want to argue, they produced the wrong kind of crisis and for the wrong reasons. First, the PA produced a crisis that operates completely within the terms of the Oslo process and do not challenge the power relations on the ground. That is, it produced a crisis by seeking recognition, formal recognition of statehood in the UN rather than escalating on the ground. That is, rather than thinking of ways to challenge the very practices that the PA claims that transform the core issues that should be negotiated in the final status, that rather than challenging these practices and the way they undermine the core issues, the PA is seeking formal declarations that is not likely to produce any real change in the conditions of the ground. In fact, the security cooperation to which the PA is committed prevents any escalation on the ground. The logic of Oslo was peace before liberation. And the logic of the UN application for statehood is statehood before independence. Oslo created the illusion of parity, and the recognition of statehood would create the illusion of equal sovereignty. In this sense, it is, the application for statehood, is the natural outcome of the Oslo process rather than a break with its logic. Now, this is absurd because it means a reversal of priorities. Rather than statehood and the PA being a means to the end of self-determination, statehood and the PA become the end in itself, regardless of self-determination. And this is the fetishism of sovereignty that you can see in arguments like John Quigley's. So, and this statehood will produce the same bad effects that the Oslo process produced, bearing the responsibilities of freedom without actually having freedom. The world looks at the Palestinians as if they were in a post-colonial stage, while the colonizers are still around and dictating their life conditions. Secondly, the PA produced the crisis for the wrong reasons. the application to the UN is not a manifestation of a political strategy. Rather, it is a manifestation of the lack of such a strategy. The PA has been committed to the negotiations process. In the absence of such a process, the raison d'etre for the PA is lacking, and specifically when there are no alternative strategies. So the PA has condemned non-violent strategies, and it made only symbolic gestures to the boycott, and specifically when it came to the settlements. And this, as Jamil said, gained greater agency after the leaking of the document, the Palestine papers. So without negotiations and without any conceivable alternative, what remains is a PR campaign. This campaign serves the PA in two ways. First, it gives a new justification, legitimacy for the PA's existence vis-a-vis the Palestinian constituency by rebranding the PA and redeeming its tarnished image. In fact, if you think of it, it was a win-win situation for everyone involved except the people on the ground. For Abbas, he was conceived as someone who's, by the Palestinians, as someone who's defying Israeli and American dictates and resisting their pressure. For Netanyahu, he was perceived by the Israeli public as someone who is defending the Israeli national interest against unilateral moves by the Palestinians. And for Obama, finally, he has a chance to realign himself with Netanyahu and defend Israeli interests before the upcoming elections. Secondly, creating this crisis improves the margin of maneuvers, the PA's margin of maneuver within the existing power structure without escalating to a total confrontation with Israel. So if we think of alternative scenarios of crisis that involve actions on the ground and compare these scenarios to the one that was advanced by the PA, that is applying to the UN, we'll find that the PA actually chose the safest route of action. Because they have many things to lose from a high-level confrontation. So the diplomatic move is safe because it doesn't give enough justifications for Israel to invoke military might. Now, the PA leaders know that the other actors, the EU, US, and Israel, have invested so much in the PA and in the security apparatus and the security mechanisms of cooperation that they wouldn't want the PA to collapse. Indeed, so any Israeli form of reprisal to this move by the Palestinians or this crisis that was produced by the PA is bound to be momentary and limited. In fact, after the gaining membership in the UNESCO, November 1st, Israel decided to withhold the Palestinian tax money. November 30th, Israel decided to release the tax money, Avigdor Lieberman's protest notwithstanding. 10 days earlier, the EU Parliament decided to give 100 million euros for the financial assistance for the Palestinians for 2012. So the PA leaders that the EU, the US, and Israel are interested in the continuation of this process and the Oslo structure, and they themselves, the PA leaders, are also invested in this process. It's a source for employment, it's a source for benefits, it's a source for privileges, and so on. So the threat that the PA will dismantle itself is disingenuous. It's not disingenuous.
Disingenuous.
Yes. Now, before I move to the legal aspect, I want to insist that the question of statehood is essentially a political question and is not a legal question. And when we focus on the legal question, we obscure important political questions. For example, in the rush to the statehood application, it was completely forgotten that every single level of the Palestinian Authority and the PLO is deficient in terms of representation and democratic procedural legitimacy. First of all, January 2009, that was the expiration date of the term of the president of the PA. He extended, by his own decree, his term for 1 year, and that ended too. The Legislative Council, since January 2006, in which Hamas won, we had no elections after which Abbas fired the Hamas government, and then we had two governments of the PA instead of one. In addition, the term of elected officials for local councils has expired in January 2009. Recently, the elections were postponed again. The Palestinian National Council of the PLO, antiquated and marginalized, is also non-representative. The PLO Executive Committee does not include the Islamist organizations like Hamas. So this may not be legally consequential in terms of international standing, because even dictators can be members to treaties and subject to international obligations. But I think it's important politically, given the issues at stake. In any event, even if we think of this question legally, I think, or I maintain, that if we think of it critically, by considering the limits of these legal moves, we will be led back to politics. There are 4 reasons why one would think that legal moves are limited in their effect in advancing the plight of the oppressed. First of all, there is a gap between law and justice, and therefore one should be careful not to conflate the application of the law with the approximation of justice. There are many reasons for this. To begin with, law is not a closed autonomous system with its own inner morality. Rather, it's suffused with politics and deeply influenced by ideology. Second, law often addresses the symptoms of the conflict and offers ad hoc solutions rather than addressing the root cause of the conflict. So it follows, even if the law were fully applied, that necessarily does not mean meeting the demands of justice. Now, the Palestinian attempt to gain statehood and UN membership implies a distinction between law as the medium for rights and politics as the medium for, or the space for, power. Now, this distinction is false, because there is no domain that is devoid of relations of power. To begin with, there is the simple fact that the UN resolutions are produced by states and political actors. They are the outcome of power structures. In addition, legal tactics do not necessarily compensate for the weakness in the power structure. The fact that Palestinians accepted the terms of the Oslo Accords cannot be fully explained by reference to bad lawyers, lack of lawyers, or bad legal moves. Rather, the acceptance of these terms resulted from the power relations at the time. For example, the fact that the Accords did not include any mention of the UN Resolution 194 regarding the right to return and to compensation is not an evidence of lack of incorporation of legal strategies in the negotiations framework. Rather, the whole idea of Oslo was premised on delaying all these issues, the core issues, to the final status negotiation. So taking a legal approach or a rights-based approach would not have changed the situation in terms of power relations in a way that would have tilted the terms of the Oslo Accords to the benefit of the Palestinians. Secondly, legalism. The law includes gaps, contradictions, and ambiguities. So it does not necessarily produce the results in which one aims at the deployment of legal action. Rights are abstract and indeterminate, and they can be used by different actors for different reasons at different times to advance conflicting positions and interests. So choosing the legal action, the legal venue rather than a political venue does not mean that it will produce more predictable results than in politics. This condition of the law makes it a medium for manipulation and political conflict. Any act of interpretation or application of the law is normatively laden, and it's performed against the backdrop of a power relation. While declaring Palestine as a state may offer the Palestinians more legal tools, there is nothing inherent in the law that makes it pro-Palestinian or favorable to the Palestinians and immune from Israeli or pro-Israeli manipulation. Third, the gap between law in the books and law in action. Even if the law produced the results that are congenial to the goals of the oppressed, it remains to be seen whether these legal stipulations have any real bite in life. The ICJ's, the International Court of Justice, advisory opinion on the war, the separation war, demonstrates that highly publicized opinions by the highest possible authorities of law can have almost no effect on reality. Attempts to prosecute Israelis in European countries, according to the universal jurisdiction like Belgium, the UK, and Spain, ended by changing the law in some of these countries given political pressure. Finally, both Israel and the US refused the ICC to join the ICC, and even if they did, the ICC cannot prosecute any crimes committed before July 2002. Fourth, legitimation. Using the legal means, despite their uncertain results and quite limited effect, is not without a price. Legal opinions or decisions may make the situation of the conflict look more necessary and more natural than it is. And even good rulings or opinions may have bad effects. Specifically, representing the conflict from the legal perspective, or the, if you want, the human rights perspective, may distort the reality of the conflict by depoliticizing it. The alleged power of the human rights rhetoric, its professionalism and its apolitical posture, is simultaneously its greatest weakness. The Goldstone report is a good example of this point by focusing on conduct during war rather than conduct justifications for launching a war, and focusing on what is perceived as exceptional rather than the normal operation of oppression. So the background of oppression, the routine operation of oppressor measures become normal. Furthermore, by focusing on the legal venue, one may marginalize other venues that may be available to the oppressed. Now, I want here to give 3 examples of the bad effects of the legal prism of the question of statehood. First, suppose the PA is granted the state status through the Security Council, or in the alternative scenario, the observer state status through the General Assembly. This means that it will replace the current observer status of the PLO with the new status, because the application was submitted also on behalf of the PLO. This substitution of the PLO with something new raises 2 questions. On the one hand, the PA is elected by those who reside in its territory, while the PLO represents the refugees. So this movement means that the interests of the refugees are not represented. On the other hand, replacing the PLO with the state status shifts the paradigm of the conflict from a liberation struggle by a national liberation movement to a conflict between 2 sovereign states that are formally equal before international law, despite the gross asymmetry of power. This would only conceal the reality of power relations rather than change it. This will again be a development of the logic of Oslo rather than a break from this logic. Second, a UN declaration of statehood would possibly affect the question of borders by replacing Resolution 181 with a new and more recent legal proclamation. There are 2 rules of interpretation in international law. The more recent trumps the earlier, and the more specific trumps the general. So Resolution 181 would be reinterpreted according to the new resolution. On the one hand, in Resolution 181, Palestine had more territory than today. So a recognition might be detrimental by officially recognizing less territory. On the other hand, today we have ceasefire lines. We don't have borders. So by having such a new resolution, we will have permanent borders. So the PA would give up territory without negotiations and for free. Third, the status of the refugees might also be affected. A UN declaration of statehood, along with Resolution 181, which, to remind you, declared a Jewish state and an Arab state, might lead to interpreting the right to return as applying only to the new Palestinian state, so not to disturb or disrupt the Jewishness of the state of Israel. So the core issues that should be, according to the Oslo process, negotiated in the final stage, refugees and borders in this case, would become, after the declaration, a permanent condition that is closer to the one advanced by Israel now. Israel will still control the borders or the areas it wants, and the refugees will not be allowed inside Israel. This means that while the PA is complaining about the Israeli transformation of the core issues, its own application to the UN may ironically lead to legalizing and perpetuating these very transformations. In this sense, the application is self-defeating. Now, all this is just to say that the law is suffused with politics, that it cannot be assumed that it is more likely to achieve that which one cannot get in politics, and that its deployment may produce bad effect. Believing that the law is apolitical while it's political, that it's predictable while it may be unpredictable, is a pure case of fetishism of the law, in which the law is, certain attributes are assumed to be inherently possessed by the law. So Namibia is a clear example. It's not, I think, a clear example of the utility of legal strategy. The ICJ advisory opinions did not lead to Namibia's independence. After the advisory opinion in 1966, SWAPO, the Southwest Africa People's Organization, declared armed struggle against the South African occupation through its military wing, using bases in Angola and Zambia. And the UN General Assembly recognized the right of Namibians to violently resist the South African occupation, including armed struggle, and called upon the other state members of the UN to help, including in military ways, the Namibians in their struggle. Additionally, when Namibia was granted independence, it was through an international deal, which was supervised by the Soviet Union and the US. The South African withdrawal from Namibia was in exchange for a Cuban withdrawal from Angola. So the difference between the outcome of the Palestinian case and the Namibian case is not due to the fact that Namibians had 4 advisory opinions in their favor while the Palestinians have only 1. What made the difference is politics. In fact, the difference between the Namibian case and the Palestinian case seems to be an opposite track of struggle. Namibians moved from the era of advisory opinions to armed struggle. The Palestinians moved from armed struggle to application to statehood and advisory opinions. Namibians gained statehood after liberation and independence. Palestinians are seeking statehood before liberation and independence. To conclude, politics is all there is. Rather than legal strategies as a refuge from politics or as a substitute for politics, what the Palestinians need is a different kind of politics. Thank you.
Professor Khalvi?
Yeah, well.
30 seconds.
Yeah, I have 30 seconds to comment on 3 papers that I didn't see beforehand. So I'm really flying by the seat of my pants here, because there was a lot to absorb very rapidly, and so I'll just touch on a couple of points. In Professor Akram's talk, I thought it was important that she did make a comparison to Namibia, because it is often forgotten that Palestine is not the only case under the sun. People who look at Palestine think that it's the navel of the world, nothing is like it, it's unique, it's exceptional, it's special. Nothing was ever like it, and in fact there are all kinds of comparisons that can be made to other mandates, other Class A mandates. Why was Palestine treated in the way it was? Why were other Class A mandates like Syria, Lebanon, Jordan, so on, Iraq, treated as they were? But as you brought up, and as Nimit brought up, the case of Namibia is also illustrative. A colleague of mine here in the history department, Susan Peterson, has done a lot of work on the differences and similarities between the mandates historically. Another thing that I thought was interesting and I look forward to seeing these two talk about this, so I won't say very much about this, were the different approaches by the Namibians to the legal issues as compared with the approaches of the Palestinians. You point out, Professor Akram points out, the shift from an assertion of individual rights by the PLO to an assertion of collective rights. And you suggest that that was the problem that led the PLO in the Oslo negotiations to bargain away collective rights, as well, I guess you would argue, as individual rights. I would suggest that what we should look at in that period of the 90s is political weakness, as well as legal failures. And I'll come to that when I talk about Nimr Sultani's talk. To the extent to which there was bargaining away of rights, I think it was very much a function of a perception of the balance of power, as well as faulty legal thinking or failure to think legally at all. And I think you've underlined something very, very important, which I had great difficulty explaining to journalists myself, the difference between statehood and membership in the United Nations. They're just two completely different things, and it's almost impossible to separate them for most people who haven't thought carefully about them. And I notice all of your colleagues on the panel are nodding their heads every time you mention it. And it's something that really is worth. I'll talk about PLO-PA mishandling of the negotiations when I talk about what Nimr Sultani said, because I think you're right. You're both right. You don't know how right you are, in fact. As far as Jamil Dakwar's talk is concerned, a couple of things. I think it's important to stress that membership in the International Court of Justice, and for that matter of the International Criminal Court, does not require UN membership. It simply requires recognition as a state. And interestingly, I think that was actually proven by the UNESCO bid. The PLO, Palestine, whatever, is not a member of the United Nations, but it has managed to achieve recognition as a member of UNESCO. The same thing should apply to all UN bodies. Now, they may or may not accept it as UNESCO has, but I think that illustrates the point that you've made, and I think you're right. And I think you're right also to look at what it was that was of most concern to Israel in this whole process. And it was very illuminating to see that Israeli ministers, the Prime Minister in particular, clearly didn't care about some things that the PLO-PA were making a big deal about, and were very, very concerned about other things, specifically the garnering of political support in capitals. And that not only was the Netanyahu government willing to give or concede an elevated status for Palestine as an entity at the United Nations, but the Israeli government supported, before Congress, further funding for the PA on the argument that the PA is doing a good thing. The PA is a good thing, and the PA is not a bad dog. It has no teeth. It's not really biting us. So at the same time that the Netanyahu government was complaining bitterly about the PA, it was urging Congresswoman Ross Lehtinen in the House Foreign Affairs Committee, she's the chair of the relevant subcommittee, to please allow funding for PA security activities. I think it's always interesting to see what the Israeli government is doing, and I think that was a good point. Now you conclude by saying what's lacking is a human rights framework. What's lacking in the whole Oslo process.
Not only human rights framework, but also IHL
and international humanitarian law. That's the next thing I was going to say.
Because this is important. It's not only rights.
Exactly. You sound exactly like one of the senior legal advisors to the delegation in Washington and Madrid, Rajesh Hadi, who argued this until he was blue in the face and eventually quit because they would not listen to him. He argued that the Madrid-Washington ground rules, which are essentially the ground rules that have obtained ever since, in fact, they're the ground rules laid down at Camp David in 1978. What Begin put forward as the Israeli position on autonomy is essentially the Oslo Accords. This interim period, it's all there. It's not just 1991. It's actually 1978. That's the origin of this. But what he said was, however disadvantaged, he and other legal, Anis al-Qasim and other legal advisors supported him in this, saying, this is a disadvantageous framework. It's bad in all of these ways. The thing that many people focused on was settlements, continuation of the building of settlements. And in fact, the delegation opposed a continuation of negotiations without a halt to settlements and without a cessation of the closure of Jerusalem, because they argued this violated the letter of assurances that the United States had given the Palestinian side, which was the basis for Palestinian participation. But what Rajesh Hadi, Anis al-Qasim, and other legal advisors argued was, you can incorporate international humanitarian law. You can incorporate international human rights framework into this negotiation if you're willing to fight for it. And clearly, Tunis was not, that is to say the PLO leadership, which at that time was in Tunis, was not. And this is for political reasons. This is entirely for political reasons. They were badly advised legally. They may not have known anything about law, but they would have taken these arguments had they been in a different political position, had they seen the political situation differently, or at least that would be my contention. Last thing about your paper, Jamil, I like the comparison that you've made to the former Yugoslavia, of how accountability was seen as coming before an agreement, and your quote from Goldstone and his colleagues. I think that's quite brilliant, because it's quite different from the approach that was taken at Madrid, at Washington, in Oslo, and in subsequent negotiations, which is that we completely forget issues of accountability. We wipe the slate clean. We are equal parties sitting at the table. You're good guys, we're good guys. We're people of goodwill. We're partners for peace. This nauseating rhetoric is just...
No, we all have blood on our hands.
And there is no attempt to argue from a position that this is in fact not an equal situation. There's an occupier and an occupied oppressor and oppressed. Moreover, it's not only an equal situation legally. I mean, you can go back to, I forget which one of you mentioned, I believe it was you, Susan. Israel's acceptance in the United Nations was premised on its acceptance of 181 and 194.
Return of the refugees.
Return of the refugees.
Question.
Jerusalem is a corpus separatum. The borders that you mentioned, the 181 borders, Israel explicitly is the only country accepted in the United Nations with that kind of conditionality. All of this is abandoned, and all of those legal positions are, I would argue, essentially out of weakness. Very quickly about Nimr Sultani's presentation, just a couple of points. I don't think we could hear enough about the fact that the entire charade of Oslo should have ended on the 4th of May 1999, one way or another. The Palestinians were forced to accept a deferral of final status negotiations, i.e. the discussion of anything of any importance: Jerusalem, borders, refugees, sovereignty, water, settlements, etc., etc. They were forced to accept a deferral of all of these things on the promise that the interim period would just be 5 years, and the interim self-governing authority would give place to a sovereign Palestinian state on the basis of final status negotiations, which would begin no later than the third year of the interim period, i.e. no later than May 1997, should have been. Well, none of that happened. So the clock ends. So when one talks about violations of the Oslo Accords in fact ceased on the 4th of May 1999. And you recall for us, in effect, Arafat being forced to back down from his saying. He didn't say that. He should have just said that and say, it all ends, I pack my bags, we close it up, goodbye, we'll start again. That's what he should have said, rather than threatening statement. In any case, he didn't, and the reasons we can look at. Let me talk last about two things. One is this fetishism of statehood, and your argument that a Palestinian state would produce the same problems as the Oslo Accords have produced: the illusion of freedom without freedom, the illusion of parity without parity, and so on and so forth. I think that's true, but I think that you should talk more about politics here. One of the big problems here is that both of these peoples have fetishized statehood to a point that it is, to my way of thinking, one of the major obstacles to going beyond the kind of paradigms that we're stuck in. Everybody talks a two-state solution, Well, I don't see how you can get a two-state solution. But how do you get beyond a two-state solution? Well, it's not just the Palestinians who fetishize statehood. I mean, Israeli discourse is all about the fetishism of statehood. People, I think, underestimate how much Palestinians have fetishized it. So they say, well, let's have a one-state solution. Well, one of your problems is, of course, Israel. The other problem is Palestinians. This fetishization of statehood is very wide and very deep. It's not just Fatah. It's not just the Palestinian bourgeoisie. It's also Hamas. It's a very large range of Palestinians. And I don't think that's going to be very easy to deal with. I already said a little bit about legal approaches that were ignored by the PLO. I think they were ignored essentially for political reasons, rather than bad legal advice. But I will say this: at least in Washington, there was legal advice. In Oslo, there was nobody who spoke proper English, understood the language of negotiations as was necessary, and there was nobody who had the slightest, had any knowledge of the legal background of this, or any negotiating experience. I mean, when people went to Madrid, they were ignorant of negotiating experience. They learned it over 2.5 years. The people who went to Oslo started afresh, whereas the Israeli team had been preparing, A. B, some of them were the same people who'd been involved in 2 years of negotiations, knew all the issues from dealing with them. And the result speaks for itself. It doesn't just bespeak political weakness, though it does bespeak that. The PLO leadership felt it was in a desperate situation in the Arab world. It had lost its support in the Gulf because of its own foolishness in supporting Iraq during the Kuwait invasion. It was dying to move from outside to inside, and it was willing to make all kinds of sacrifices. That was the basic point. But having incompetent or no legal advice made the situation much worse. I want to take issue with two things, though, that you said, Nimin. You're completely right about the fact that the terms of every single Palestinian representative body have ended. The Palestinian president, the Palestinian municipalities, the Palestinian Legislative Council, their terms have ended. They have no legitimacy any longer. The PNC was never elected, except some unions elected their members, but those are the only ones. But I think there's a problem in your arguing that a Palestinian state would be the state of the PA, and that the PA was only elected, even though those elections had lapsed, by the population of the occupied Palestinian territories. Why would that state not be the state of Palestine or all the Palestinians rather than the state of the PA? If, as they suggest they're going to have, the PLO has elections for the PNC in May of 2012, and you have an elected representative body, which nominally at least represents all Palestinians except Palestinians in Israel, then, and if the state is proclaimed as the state of the entire Palestinian people, I don't see that the problem that you've raised necessarily raises its head. The only body by the Oslo Accords themselves, which is authorized to negotiate on behalf of the Palestinians, is not the PA, it's the PLO. And presumably this PLO, this Palestine state, would be a state of the entire Palestinian people as represented by PLO. I don't see that. The second thing that you talk about is that a UN statehood declaration would replace 181 with a new resolution. Now, it obviously would depend on what resolution might be adopted, accepting Palestinian statehood, and it would depend on whether such a resolution refers to borders, and what borders it refers to. Presumably it might refer to 1949 borders, though with the Israeli government's position determining U.S. policy, that won't happen either, so probably borders won't be mentioned. But the idea that the PA would thereby give up territory seems a little strange to me. Where are these 181 borders? How does the PA have these borders now? I mean, in what sense are these borders that you can say are, in fact, formally claimed by the PA or any body of Palestinians? Now, you can say, well, the PLO in 1988 in its Declaration of Independence grounded that in General Assembly Resolution 181 and implicitly suggested that those borders have some legitimacy. But that's implicit, that's not explicit. I failed to see that, as I failed to see how the right of return would necessarily be given up. Unless the resolution explicitly says that, I would say that, and I can't see that. I don't see this. I think I'm going to stop now. I could say more, but I'm sure people have questions, and we only have 45 minutes, so. Do you want to recognize questioners? There's some behind
Yes,
you.
please. And would you just give your name with your question?
Frank Bamberger. I hear all four of you quite critical of the Palestinian Authority, PLO. I'm wondering where there might be change. Is it the case that the Arab Spring has bypassed the Palestinian polity? Where is the possibility of a change, which, from what I hear from you, this has been going on for decades?
You all may want to say something. I'll say something very quick, which is that The Arab Spring, to my way of thinking, represents the end of an Arab obsession with the colonial era and with the remnants of colonialism, and the end of a false nationalism which grounded dictatorship in past achievements against colonial governments. Now, the Arab Spring represents an understanding of the problems of the Arab societies. They're essentially internal.
Yeah.
The Arab world has finished the colonial era. Palestine hasn't. Do you deal with your corrupt, foolish rulers in Mercedes and Audis, Palestinians, or do you deal with the Israeli occupation that treats you like an animal every time you try and get into Jerusalem, or every time you try and... I mean, it's a situation that the Arab world dealt with in the 30s, the 40s, the 50s, 60s. It made parliamentary politics impossible. It made the politics of newly independent Arab countries impossible because neo-colonialism continued basis and so on. So that era is over in the rest of the Arab world. That's one reason the Arab Spring has some unequivocal characteristics. Palestine has not finished the colonial era. I mean, literal colonization is actually going on even as we speak. So, in the West Bank. So, I think that's part of the problem. And I actually don't think the Arab Spring has not reached the Palestinian territories. Two entrenched leaderships so deeply immersed in their perks and their privileges and their power have been forced against their will to contemplate a possibility of a reconciliation solely because of the Arab Spring. That's what's changed in the Arab world. So I'm not sure that that's going to lead to anything, and I don't think those two leaderships have any imagination or any strategy at all, and putting 0 and 0 together might give you 0. But I do think that there has been an impact of the Arab Spring. That's at least the beginning of it. But the Arab Spring is at the beginning in any case. Do you have a...
I think the potential of democratizing Palestinian institutions, which is, I think, a big potential there of trying to go, not only the PLO, but the ones that are... PLO is about breaking the boundaries of the Oslo framework. That's in the first place. So you can have democratic representation of all Palestinians. And then you have what exists under the Oslo framework that clearly is delegitimized because of what happened since the 1993. I think that there's also the point of how do you deal with the situation where Palestinian Authority that has created itself as an entity that perceives itself as a sovereign over a territory where it is not a sovereign and is negotiating under this premise. That's, I think, the illusion more than anything. Oslo Accords created this internal self-determination at best for the Palestinians under the framework of Oslo, which was conceived in the Camp David. The external
David 78.
Yeah, 78.
Clinton.
Not the one.
Carter said that.
Right.
Carter said that.
The external right to self-determination, if you wish, which is the fundamental one, which where you anchor the state's recognition and independence, has been lost, has been undermined by the same framework. That's why you see all those main issues have been put aside, and they all of a sudden PA became a security subcontractor in the last couple of years, maybe 3 years, even economic advisor for the state of Israel, how to run territories. Maybe that's kind of so I think there is a potential for creating that. I think the fact that you have more accountable regimes in the neighborhood, in the Middle East, where you have not only inspiration and kind of moral, symbolic thing, but actually people who are governments that you can try to have them as your back when you are trying to take a bold move in politics.
You might want to suggest that they not only answer questions, but answer each other.
Yes, please. No, that goes with
Okay,
Take
I'm
your
dying to
opportunity.
answer Nimra.
Take the opportunity.
And my answer, Nimra, is 2002, Kofi Annan said, "There is no conflict in the world today whose solution is so clear, so widely agreed upon, and so necessary to world peace as the Israeli-Palestinian conflict." I agree with you in the abstract that law can be interpreted in many different ways, but in this particular conflict, we have a set of core principles that have been reaffirmed and restated, and now finally we have the imprimatur from the International Court of Justice on all the key points in the 2004 advisory opinion that tell us what the legal framework is to resolve this conflict. full stop. So I mean, your presentation reminded me why I'm so allergic to politics. But I totally agree with you that, of course, politics and law are intertwined. And I was not suggesting in any of my presentation that law was the answer, but that the Namibia case showed us that law has a central role to play, along with the armed struggle, negotiations, civil society action, and every single tool in your arsenal. But if you leave law off the table, you have no possibility of getting civil society to go along with you, to work with you, and you certainly have no language at the international level to persuade that you have a case to be made. And that's what I was trying to show with Namibia. Not at all to be so simplistic as to say that law is going to be the raison d'etre of the entire conflict or provide us with the only means forward. So I hope that I make that very clear. On the question about why is the international community not behind statehood, I mean, what international community? We can look at, on the one hand, state actions. We can look at civil society. And I would say, being familiar with civil society work within the UN for several decades now, there are over 1,000 NGOs that have been working with the Palestinian unit within the UN on so many levels, at the UN treaty bodies, at the Human Rights Commission, at the UN Council, working in every possible mechanism, and Jamil knows this as well as I do. There has been tremendous collaboration to support Palestinian individual rights and support the foundation for eventual statehood. Unfortunately, those of us who have been engaged in that struggle have been engaged in it as opponents to the Palestinian delegation. I'm very sorry to say that's the reality. And that if the Palestinian delegation, for example, on the ICJ opinion, does not take the results of that opinion forward, no amount of work by civil society is going to advance that opinion's results any farther. And that answers the Goldstone report in the same way. There was tremendous amount of civil society work to promote the Goldstone report and move it forward and have some implementation. But it's been blocked by inaction by the Palestinian delegation. I totally agree with Peter that, and part of the point that I was hoping to make was that the most important thing that the PLO/PA should have been doing all along was working in its bilateral capacity with other states, building those frameworks, getting a consensus on what the law required, and in that way, that was the work that was so interesting about Namibia, because that's what Namibia was doing. And SWAPO, including SWAPO as well as the Namibian Council, developing that framework so that when it came to state-by-state relations, the states had a framework that said that South African occupation was illegal, an agreement on the sanctions regime. None of that work has been done by the PA and PLO over all these years. So it's not to say that the move for bilateral statehood is wrong. It's too little too late, with the foundation work not having been done in the meantime. I'm not going to say anything about Hamas, so I'll leave that to you guys. Yes, I think Neta's question is a good one, and I think the ICC case is an important case because I think there was some sense within the ICC that they would wait to see what happened with this bid to see whether it would be an easy question to recognize Palestine as a state or an entity like a state for purposes of ability to prosecute. But I don't know whether that's going to be moved forward, and I certainly know who the Minister of Justice is. I think he's got some very good legal advice. I'm not sure about his own capacity, but there's been some very good legal advice now for a number of years about how to move the case forward on the ICC. I'm not sure it's been done organization by organization yet, but maybe now the UNESCO will be the first. But this is where the important work needs to be done.
So I have few, four things to say. First, to Rashid. So, of course, I was talking about the likelihood of certain scenarios, so we don't really know until we see the text. But I was suggesting that these scenarios will open the door for different interpretations with regard to the refugees and the borders. Interpretation, if they would be advanced by Israel, they will not wouldn't be completely false or easily dismissed. So, if there were a resolution by the United Nations in which the borders would be delineated, then this would be the first time that the Palestinians would formally and explicitly give up the full territory. So you say that it's implicit now, but this will be explicit. Now, the way I understand negotiations is that it's tit for tat. You wouldn't give up anything for free unless you get something in return. For example, what happens with refugees? If you want me to give up 77 of the territory of historic Palestine, then what happens with the refugees? Let's admit more into Israel or something of this sort. The PLO, given the fact that it's not represented today, it cannot act, as far as I can judge, on behalf of the refugees. It does not represent the interests of the refugees. Therefore, the refugees remain voiceless in this process, and therefore I don't think the process is appropriate in which the PLO decides that the PA would be representing the Palestinians in the form of the state, in which case, of course, all talk about the refugees and the settlements and so on would continue as slogans, but only as slogans because, in fact, what will happen in practice is that they will be securing the state and the minimal peaceful relations with Israel, because Israel is the one still controlling the borders and the VIP passes and so on and so forth. So this will be the main or the primary function of the state, as well as the mundane functions that states generally perform, and the refugees will recede into the background, and the borders will become permanent. So this is would be the first time, possibly, of formal declaration of giving up the historic rights over these lands. Secondly, to Peter, so I didn't say that the law is the enemy of politics. So maybe I should clarify my argument. My argument is not ontological argument. It's phenomenological argument. That is, I'm arguing about a form of consciousness, about the perception of law and the role of law and the way you use law. And do you perceive the law as a means to an end or an end in itself? Do you attribute to the law properties it does not have, such as predictability? So I'm arguing about the Palestinian experience so far with the law. And I think the Israeli-Palestinian conflict is actually one of the heavily legalized conflicts in the world. I don't think the law was really absent and that the return to law would resolve the political impasse. So in this sense, I'm arguing against the way we perceive the law. And to Susan, I'm not, so in the same sense, I'm not against the law. I'm not denying that the law has a role to play or that it's valueless. For example, I think the ICJ is a valuable opinion, at least in terms of argumentation, but in effect, did it move anything on the ground? No, it did not. Would a second advisory opinion by the ICJ move things on the ground? It's likely not, given the experience. Maybe I'll be surprised, but maybe the Messiah will come tomorrow, who knows? But our experience with the law so far suggests it's unlikely to change things in any significant, profound way, which leads me to my last point, which is the Palestinians should decide how to, what kind of political strategy they will have in the coming years, and how the law might play or not play a significant role in that. So I think what should be guiding the Palestinians is the following basic assumption, which is there will be no just solution for the Palestinian question in the near future. And this should be the basic assumption upon which political strategies to advance the Palestinian cause should be. And if we think that certain legal strategies can advance the Palestinian position in certain areas on specific issues, then this should be done, but only instrumentally.
So I wanted to clarify first, my intention was not to argue that we don't have a recourse to international bodies and we don't have the potential of expanding the avenues of seeking some sort of attention and a remedy or some sort of accountability. But my argument has been more focused on this should not be the end of itself, and I agree with you. But I identified why in such a political mismanagement or leadership in disarray would turn an accountability and discount the importance of accountability to the level of almost making it meaningless. I propose that if we really truly committed to accountability, and I think the Palestinian Authority was not, and I believe that they're still not committed fully to accountability because there's a number of ways that they could have improved their performance. There are some ways that you can achieve that. I totally agree, and that's what I said, Peter, in the beginning, that the bilateral approach for recognition of the state, the political recognition, but is fundamentally based on international law and international precedents and framework, is the way to go. And rather than this whole distraction that only, again, created this unintended or maybe unintended consequences or results that where we could have kept that. Again, I don't want to prejudge the strategy overall because I said in the beginning, we may not know all the details of how that was put together. But I'm suggesting if that was what was intended, then they went to the wrong direction. And rather than continuing with those bilateral tracks, capital to capital, building the recognition of the Palestinian, at the same time understanding that what is the framework is. And here's where I suggested the rights-based approach is not only about accountability for human rights, but it's also a clear understanding of the legal status of Palestinian people and Palestinian territories under which we are trying to get this recognition. For example, Article 47 of the Geneva Convention, the Fourth Geneva Convention, makes it very clear that, and I want to quote because this goes lost into the whole discussion. Here's what it says: protected persons who are in occupied territory shall not be deprived in any case or any manner whatsoever of the benefit of the present convention by any change introduced as a result of the occupation of a territory into the institutions or government, nor by any agreement concluding between the authorities of the occupied territories and the occupying power, nor by any annexation by the latter of the whole or part of the occupied territory. Now that is what I'm talking about when I say, before we come to the negotiations, let's set the rules clear. Under which framework are we operating? And I know that that's been an attempt by people who are older and more experienced than us in dealing with the Palestinian legal question. And I go to my point. I don't want to substitute political strategy with the legal strategy. I want to have a political determination, a political strategy that is supported by a good and solid legal options that will get you where you want to get. If you understand that you want to hold people accountable, this is where you do it. If your end or aim is to get recognition and statehood and independence, here's how you get, and this is what you need to do. The issue of universal jurisdiction, absolutely. I wanted to raise the ICC because I wanted to make sure that we understand why the Israelis were so worried. On the universal jurisdictions, they were worried because, on the ICC, they were more worried because it sets such a framework and or a ground for future possibilities of, again, before 2002, you could do nothing, okay? Settlement activity, of course, there's ongoing settlement activity. You can fall into that. But what you set by that, when you have a recognized state and you're operating under that, then, okay, one time you're not convincing the prosecutor. Next time you're going to fail. The third time it's going to happen. And that's really what is worrying the Israelis. With universal jurisdiction, they can deal diplomatically with one country, country by country. You go, you use your lobby in those countries, you invest in what happened after the Belgium case against Sharon. Similarly, they tried and unsuccessfully, I think, in London, in the UK. In Spain, there is ongoing case. But I think the ICC, even if I'm critical of just many others, understandably because of the political constraints on it, with how much it can take. But you are talking about a long-term struggle for accountability. Well, I'm not talking about 5 years. And the Goldstone report, in my mind, not because I think, I think, Nimer, I should say, the reason that it was an important milestone is because, yes, when you are going to seek criminal accountability, you're going to follow the facts and the law. You can't just go all over the place and look for accountability. And the criminal scene has to be preserved. The criminal evidence has to be preserved, documented. And there's rules for that. And that's what I'm talking about. I'm not talking about human rights in general, about promoting, protecting, realizing the rights of. That's important to do. But when it comes to accountability, that put people behind bars, as we saw in the ICTY, as we saw well, now they're too early to see what's happening with the Arab Spring. But that's what I'm interested in. I'm interested in those efforts that will be able to, yes, look at specific, the cases that went into the Yugoslavia were mass graves, specific cases. They got assistance. That's why I cited the fact that the whole ICTY was put together. They got the assistance from the different parties to the Dayton Agreement, in the Dayton Agreement. Judicial assistance, access to mass graves, all of that, of course, I'm not saying that was perfect, was not ideal, but it set an important precedent. And I think it is important for us as Palestinians and people who believe in accountability to go and find every good precedent that we have, able to illustrate that, yes, there are a lot of political constraints and we are not politically empowered, and the law may not be on our side, but there are certain ways that you'll be able to mobilize. And I totally agree with Susan with your comment about how to get the language that you speak, the language of people. The PA, I don't know if you noticed that. Some of the people who were rooting and mobilizing for the PA bid in the UN was one of the leaders of the nonviolent resistance against the war. They, I don't want to name names, handed him the kind of file of mobilizing support for that. I think that is an attempt to co-opt nonviolent resistance against the war, something that is based on under the ICJ advisory opinion. There is now activity that's been going on since 2005, 2006 with Belain resistance. And yet you have political forces that come in and you want to co-opt and send them, no. Don't pay attention, or, you can pay attention, but you know what? Our real struggle is in the UN in New York and not in what you're doing. And there's all this. This is what needs to be investigated and exposed. And I think that is the only way that we will be able to march and say to the people, I do care about what the Palestinian leadership projects, what it promises, what it does not promise, even in the absence of full independence. I'm not saying to fault the Palestinians to start to blaming the victim, obviously not. My whole point is you cannot expect from people who hold diplomatic passports or VIP passes to continue with their lives without recognizing that they owe responsibility to the people. And I think the legal accountability issue is going to haunt them. And when I say human rights accountability and accountability for international law, is not only for Israelis, by the way. I think that we have to be very careful about the way that we're using accountability mechanisms. One of the things that this will also do will deter future Palestinian leadership for committing crimes such as torture or subjecting people to the death penalty or other abuses that happened, even if we didn't have the full independence of a state. And now, unfortunately, because of the way that it's being conceived, more accountability is directed against Palestinian leadership, including Hamas, and that gets it to the lower final point. I think when it comes to Hamas, there's the issue of their responsibility as holding power in Gaza. What does that mean, legally speaking? How do they interact with the outside world? I think the unity agreement, will hopefully bring them to the point where they will bring Fatah to the point where they understand what are the limitations on bargaining with Israel. But one of the things that maybe Fatah will be able, or the Palestinian people as such, will be able to bring Hamas to, is what are the responsibilities that they take under international law. And one of the things that the Goldstone report did, and you can again condemn it or not, and I am still critical of the way that Justice Goldstone have come out, but I don't think that it really should be, this helps us with this, is that it said, in this situation there are also accountability, there's also responsibility for the Palestinian Authority, including the governing government in Gaza. So the problem that will complicate things is the 4 conditions of the Quarters. If you have a unity government with Hamas, with the potential of US declaring it state-sponsored, at least the threat of state-sponsored terrorism, because there are 4 countries that are declared such. Cuba is one of them, Sudan, I think, Libya until recently. There were 4 countries that are declared under the Department of State. And the way that these will be used, these conditions of accepting international agreements, recognizing Israel as a Jewish state, renouncing violence, all of that, I think that we have to look at other good experiences. In Northern Ireland, the IRA turned their arms after the agreement was already signed and after they have already received the power sharing agreement and it has already been into place. And you can go back to the date, and I remember that vividly because it was clear. They kept their arms till the very last moment, and then Mitchell was the one who negotiated that treaty. Again, it's not imperfect, it's not the same equivalent situation, circumstances, but we ought to look at those examples where, yes, people pushed back against ways of saying, well, you got to give everything up from the beginning. And at the same time, there are certain obligations you take on yourself. The PLO accepted, at least, I think, the Geneva Conventions as a rebel group, as part of a liberation organization. To what extent Hamas is accepting the Geneva Conventions? Are they really committed to the Geneva Conventions? This is part and parcel of that agreement, and when I say, bringing it to the place where we have solid framework, it will also have to engage Hamas. And I totally agree with you. Despite their designation in Europe and the United States, they are part of the Palestinian people. They took part of the elections that were ultimately ignored, and yet now Israel can negotiate the release of a prisoner, but they cannot negotiate with the same organization for larger humanitarian reasons. I mean, with all due respect, there are, yes, it's important to look at the humanitarian situation of kidnap, and it was illegal captivity of Gilad Shalit, but to turn it into a place where not every single government had to take the floor, had to condemn the kidnapping of Gilad Shalit, while at the same time not recognizing what is happening in Gaza, has truly turned things upside down. So I think going back to the basics. What are the basics? How do we really negotiate, and how do we get the Israeli government to do the right thing? I think the Israelis built a track record of, while ignoring and oftentimes intentionally violating international rules, they clearly have created a track record where they also try to understand the way that they want to implement international law, the way that benefits their political leadership. You may agree or not, but when you have Meron Theodore Miron, who is now the head of the, I think, the ICTY, is a judge in The Hague. When he was a legal advisor to the State Department, to the Israeli Foreign Ministry, he wrote the first legal memo on the settlement. And he reached the conclusion at the time that settlement activity, sending your own citizens to occupied territory, would be in violation of international law. Now, you may argue whether that is helpful or not, but for what it's worth, yes, sometimes you will find those moments where the law will come to you, or you will have to find the law beside you to help you build your own independence, your own future state.
I think there was one quick question, the second part of your question that didn't get answered, the change in the Security Council. Was there sort of a change in the balance of power? And honestly, it doesn't matter because it's the veto of the 5 permanent members that counts. If one permanent member of the Security Council vetoes a resolution, it doesn't matter what the rest of the balance of power is. And that's what we have here at the Security Council. I just want to say one of the points that I wanted to make about what I was trying to make about Namibia was that you actually did have the same situation in the Security Council with Namibia. You had the US and France vetoing the Security Council resolutions that would have enforced the framework that had already developed out of the General Assembly. And especially the embargo question had been vetoed several times. A sanctions regime had been vetoed at the Security Council. But my point was that that did not stop the fact that the legal framework was already being developed through these advisory opinions, and in the bilateral relations between the rest of the states and South Africa, they were kind of told what the law was, and they began the sanctions regime without approval from the Security Council. So that was sort of the point I was trying to make, that parallels where we are here with Palestine.
Yeah, I would like to add only 3 points. I'll be succinct. And so with regard to the Goldstone report, I think what I'm trying to get at is not that we should not have accountability or we should not have legal reactions and repercussions for crimes committed in places like Gaza. But the question is, to what extent these are a reaction to the occupation, or they are just a reaction to the symptoms of the occupation? Do they address the symptoms, or would they ever, if they accumulate, would address the occupation? You can try another Israeli general, another Israeli soldier, and another one, another one, another one. That would not lead to the occupation forces leaving Gaza. 1. 2, Goldstone was a huge report, and I'm critical of the report. I'm not critical of his reversal afterwards. His reversal afterwards is clear for political reasons. But the legal perspective of the report was limited, and we should see the limits and not only the good side. The good side is, yes, we have the distinction between civilians and combatants, and we have proportionality. But what does proportionality mean in the larger view of things? It means that Israel is not justified in killing 1,400, but may have been justified in killing only 400. That's what proportionality means. Proportionality means that when a kid, 9 years old, steals your apple, you cannot shoot him in the head with the gun, even though you are justified in holding him accountable for stealing something that is your property against the law. Proportionality is about a proper. So Israel, according to the Goldstone report, was justified in reacting to the Hamas and Gaza because the Goldstone report relied on the international law distinction between jus in bello and jus ad bellum, conduct during war and conduct and the justifications for launching a war. It assumed that Israel was justified in reacting to Hamas, and therefore the question was only about whether the means are appropriate by which Israel. Now, the ICC is also about the symptoms. It's about holding soldiers accountable for the crimes that they should be held accountable. But that wouldn't lead to the occupation or the whole structure of power that leads to the commitment of these crimes. So, my critique of the occupation is not about, a moral critique. It's a critique of the structures of power that produce these conditions of violations of basic rights. Second point, international law, while useful in organizing our understanding of the conflict through categories, it might blind us from seeing the connections on the ground. These categories do not always overlap with reality. So I'm not against distinctions and categories. I'm against categories and distinctions that have bad normative effects. For example, there are three categories of the Palestinians: the Palestinian citizens of Israel, the residents of the occupied territories, and the refugees. These are distinct categories under different rules in international law. But are they distinct in reality? No. We have refugees in the West Bank, and we have refugees within the Palestinians inside Israel. We call them the internally displaced persons. So the category refugee is not entirely external to the category citizen or the category protected persons or residents of the occupied territories. And I can also go on about the distinction between the resident of the occupied territories and the citizens. I don't think this distinction is a distinction of kind, but a distinction of degree. That is, it's only different degrees of oppression that the Palestinians inside Israel and the Palestinians in the occupied territories are subject to, but it's the same system that produces these oppressions. Thirdly, I think sometimes the law or the legal perspective may preclude different solutions of the conflict. International law, specifically, is based on the Westphalian conception or the nation state as the cornerstone of international law. And between World War I and World War II, what dominated the discussions, the legal discussions, was the idea of separation as the solution for national conflicts. And therefore, if we want to think today about a one-state solution, I think the basic premises of international law preclude, to a certain degree, the one-state solution.
Just quick responses. One is on the proportionality. I think that, Nimir, it's not only, it may be true in some cases that the proportionality test would sound like it's horrendous, but I think you have to read it as one of many other tests that has to be met. It's not only the proportionality. In fact, in the human rights law, the proportionality test plays greater role than under international humanitarian law. But I don't want to get into too much of that, because I think there is other areas, for example, of the military advantage, the necessity of, there's a number of other tests and requirements that need to be met and examine the action at stake. The second thing is about, yes, it's true that you cannot take the whole occupation to the ICC or to international legal, although you can come close to that, unless you're doing like a Russell Tribunal kind of thing. But the crime of apartheid is recognized under the ICC. So you may think about a way that you can target you can analyze and look at what's happening in occupation as a system of oppression in the prism of a crime, but they're certainly limited to what those institutions are intended to be, and they are as good as they are held themselves accountable and pressured by both peoples, governments, good-intended, or governments with good intentions. So I do not preclude completely the importance of such mechanisms and such bodies. I think that that is actually one of the ways that you can break down. If you are trying to, the CERD, for example, the Convention on the Elimination of All Forms of Racial Discrimination, you can, under certain circumstances, bring a case before the committee with regard to particular practice of the state. And once you are bringing the whole narrative, the whole context before this committee, you are able to tell your story. You are able to overcome this individualized, out of context sometimes cases of accountability. So there is a way other than just saying, oh, it's everything but that. I think that your critique of the law and the practice of the law, particularly international in this case, is valid as long as it leaves room for this law to be able to be used and utilized for a good end, which is the end that you believed in, which is the political end. So I think we agree on the overall picture, but we may disagree on specific cases of how you can utilize law in order to get accountability. And particularly in the case of statehood, we see how a legal strategy, when it becomes the main strategy rather than the political strategy, it kind of maybe dilutes the whole political context to the extent that people start to ridicule really what their intentions here, and it does not serve us, and it may hurt us more than it served us.
I think the Goldstone report actually came close to talking about the illegality of the blockade cost.
Yeah, but on the other hand, the Goldstone report was commissioned by the UN against the background of what was perceived to be as something exceptional outburst of violence in the life of the conflict. So it assumed as if, the days in which there was no outburst of violence between Hamas and Gaza, the daily life of Palestinians was free of oppression. But it's this background of oppression that I feel is obscured by, viewing the Gaza conflict, the Gaza war, as if it were something exceptional. It's not exceptional. It's only one manifestation of life under occupation, and the high regard to the Goldstone report also obscures the fact that there are so many things that remain silent, that remain unspoken about.